There we go. Our next presenter today is Aaron Marcus, who is a civil rights attorney with the Defender Association of Philadelphia. He earned his law degree from the University of Minnesota in 2004, where in addition to his educational pursuits, he served as editor-in-chief of volume 22 of the Journal of Law and Inequality. After completing his education, Aaron worked as a staff attorney for the Third Circuit of the U.S. Court of Appeals, and in 2006 he moved on to the Defender Association, where he stuck. In addition to his direct legal work, Aaron is an adjunct professor of law at Widener Law School, teaching criminal procedure. He has written and published on issues of drug policy, policing, and federalism. His articles have appeared in the William Mitchell Law Review, the Kansas Journal of Law and Public Policy, and the Whittier Journal of Child and Family Advocacy. Aaron is now specializing writing and lecturing in the area of sex offender registration, law, and policy. Bless him. He's going to bring us up to date on some activities in Pennsylvania in the recent months and give us some insight on that. Aaron, it's great to have you join us today. After our little interlude, the forum is yours.
Oh, good morning. Thank you very much. So we're good to go? All right, thank you. All right, so thank you very much for having me here today. It's a great pleasure to be here. My name is Aaron Marcus. I'm the chief appellate defender at the Defender Association of Philadelphia. It's really wonderful to be able to talk to everybody today about what is obviously a long-standing and very important issue in this nation, and one that is rarely and unfortunately addressed far too little in this country. But every person who has come here today to listen and be part of this conversation, in one way or the other, I mean, you're all here because you believe in justice, you believe in science and facts, and frankly, you believe most importantly in the value of redemption and growth, and that, and in human dignity, and that no person can be defined solely by the worst thing that they may have done, right? But if you're also here, you absolutely know that pushing back against these sorts of reactionary policies and the registry, and fear and misguided assumptions about people and their actions, it's a long and difficult fight. Hope is obviously easily quashed, and victories are unfortunately few and far between. For me, right, I've been practicing law for 15 years and have been challenging Pennsylvania's registry for almost a decade. And in my state, we've had a lot of successes and unfortunately a number of failures, right? But despite our best efforts and the many successes we've had legally and in the sphere of the public arena and the public conversation, a conviction-based categorical registry still remains in Pennsylvania. It now burdens about 22,000 people in my state, and it's alive and still mostly well, although there's a number of chinks in that armor. But I come here today because I really think it's valuable and I was asked here, for you to all take a journey with me through the fight that we've done in Pennsylvania, through our losses, through our successes, what we've learned, and what lessons can be taken from both of those things, from the successes and failures, what we did right and what we did wrong. So as you all know too, this is a long game, and unfortunately a very long game. And things won't change quickly in this country, nor will they change quickly in individual states. Every major success we think we've had in certain places like Michigan and Maryland and in my state, Pennsylvania, is met with resistance and changes in the law, and ultimately trying to re-solidify the exact or very similar things that we just overcame. But my hope is by sharing stories about what people are doing around the country, what we have learned and the things we have succeeded in doing, we will be able to push back against that sort of tough on crime boogeyman, that, the fear of the monster in the closet, those irrational and illogical gut instincts that many people have. And I know that we've been successful in doing that around the country, and the tide is changing. But I hope that by talking about this and inspiring people and teaching about what we've done, we can all learn lessons for the fight yet to come. So a little bit about me, just really quickly, before I get into the specifics of what we've accomplished and where we've obviously failed too. As I said, when I started, I've been doing this for a while now, but when I started practicing criminal law, I really had no involvement in registration issues. I was becoming very versed in Pennsylvania criminal law. I tried many, many cases. Dozens, if not hundreds of trials, represented many, many sex cases. But you know what? The registry and sexual offense collateral consequences, those things still boggled my mind early in the days of my practice. And it didn't help. And the reality is, this is true for most criminal lawyers, right? The registries across the country are incredibly complicated. And Pennsylvania's is no exception. And this is the type of stuff that, despite how important it is for people, right, and how important it is for our clients when we're representing people charged with various sexual crimes, it's so difficult to understand the nuance and the intricacies of this. And as many of you may know, the law in both federal and many states says that these sorts of consequences, registration laws, are not something that is covered by Sixth Amendment rights to counsel, right? There's no effective assistance of counsel right with respect to registry information in most states, and certainly not federally. Therefore, there's no incentive, legal incentive, for attorneys to talk to people who are charged with sexual crimes about these laws. So attorneys gloss over them. I was no exception. Megan's Law being such a mess in Pennsylvania, and I'm not going to go through the details of our history. As you all know, it's been incredibly complicated around the country, right? It's been 25 years since the first registry law was passed, roughly around the US. And since then, in Pennsylvania, we've had 5 major changes to our laws, with 8 additional minor amendments in between that changed the length of time, who's covered, what they have to do, the types of crimes, retroactivity provisions, affecting people backwards. These things changed every 2 to 3 years. Attorneys just gave up trying to figure out how to deal with it. But that said, when SORNA, Pennsylvania's Sexual Offender Registration and Notification Act, was passed to adopt the Federal Adam Walsh Act in 2012 in Pennsylvania, it just I knew that something had to be done, because I realized very quickly how broad this was. So many crimes, 144 categories of information needed to be reported, felony convictions upon failures to register. Thousands and thousands of my clients at the Defender Association were going to be affected by this and going to be hurt by this law. So I absolutely knew that we needed to do something. And myself and some colleagues immediately jumped in and said, you know what, we've got a little bit of time before the passage of the law in 2011 was when it was technically passed, and it was a year implementation effectiveness date in December 20th of 2012. And that year window, myself and a few colleagues realized we've got to develop a game plan. And that game plan has ultimately turned out to be very successful. So it's incredibly important to have that long-term plan, especially in areas where you're going to encounter both political and legal backlash, right? This is not something where we can easily change the game. So that game plan has to be long and has to be detailed. So what did we think, right? And this is going back to about 2012 and what our thoughts were for developing basically a 10-year plan, which we're coming up on, and we're basically on task. First, go after politically palatable issues, right? Things that aren't going to raise red flags for most people, aren't going to attract media attention, or will enable courts to basically decide these questions without feeling gut instincts that they can't make these changes, because we knew we're not getting anywhere with the legislature. So we had to go after what's essentially low-hanging fruit. And I'll talk about what some of those things are in a second. We also had to challenge things we thought in criminal court. And of course, this is connected to what I think is important, what I mentioned before, right? Federal and Pennsylvania law does not, in most cases, say that registry laws are punishment, and they didn't back in 2012, and there's no right to counsel. So in order to get the most people into court making these challenges, finding the most sympathetic and equitable cases to be those sort of lead claims, we needed to know that they needed rights to counsel because so many people don't have money. So we had to do it in criminal court, and we tried to figure out a way to go. And third, we found partner organizations to help us, not only legally, but also in the public sphere, make good arguments, attract support from organizations that might not otherwise seem like real partners in this, but we all have an interest in just criminal law. And finally, most importantly, right, we realized very quickly that we needed to teach, if we're going to go in criminal court and make these challenges, we needed to teach criminal justice participants about registration laws. And this is key, right? It's absolutely key. Because what we knew before and what we know now is that the people who work in criminal courts, the judges, the district attorneys, the defense attorneys, the clerks, everybody, finds registration laws incredibly burdensome and difficult and onerous and hard to deal with, right? What the law says and what they feel in their gut, they know that these laws, even if they think they are good, create problems for the court system, and they don't like dealing with them. So we wanted to teach participants about how the law works and how it doesn't, right? Showing how it's ineffective, showing how complicated it is, because we wanted to start breaking down the emotional barrier and getting people on our side. So ultimately, years down the road, they could rule on laws that, you know, in our favor. And we thought it was really important. So we started doing that around the state. All right. So those are one of the most important, I think, lesson 2 here, that is the most important thing we did despite all of the attacks. And I'll talk about those real quickly, but really teaching people, getting them to understand how it works and how it doesn't, finding people who are, you know, respected in the legal community to go out and lead these trainings and lead these events. And I started doing it with my colleagues all over Pennsylvania, teaching judges at state judicial retreats, teaching county bars, teaching probation officers, going to the state probation conferences and parole officer conferences, teaching anyone I could, because I thought they need to understand the flaws in this system. But of course, right, in doing that, that's only part of the game. So we had to actually bring the legal claims. So let me talk about how we put them into action. We knew we needed to diversify the attack. We needed multiple claims and multiple cases, right? So we really looked at 3 areas that we thought, as I said before, were that low-hanging fruit, right? The things that we could attack that wouldn't raise the specter of that emotional boogeyman that people are so ready to jump on to cut down and undermine all of the science and the knowledge that we know about these laws and their ineffectiveness. So we looked at kids. Pennsylvania was requiring juveniles, so people under 18, to register for sexual adjudications in juvenile court, right? We needed to attack that law. We wanted to attack statutes on their face and try to say that certain definitions of those laws were not as expansive as they were being applied, basically narrowing the power of narrowing statutes to apply to fewer people. And third, the idea of plea bargaining, right? So these 3 areas were what we wanted to attack first, and we did all 3 with different partner agencies around the state. So first, right, let's talk about kids. The first thing we wanted to do is find partner groups and agencies to attack Pennsylvania's law that registered juveniles as offenders in Pennsylvania. Now, what Pennsylvania was doing is consistent with a lot of other states. It said anyone who was adjudicated delinquent, so in juvenile court, who was 14 years or older, who committed one of the more serious offenses, rape, sexual assault, a number of the more serious crimes, was then registered for life in Pennsylvania. They'd be placed on the public registry. There was no avenue for removal. It was an incredibly difficult, onerous lifetime restriction. We knew early on that, this just as a gut instinct, felt wrong to a lot of people. And our primary strategy was to focus on what was called the irrebuttable presumption doctrine. Pennsylvania has this unique, wonderful, expansive constitutional provision that in our Declaration of Rights, Pennsylvania's Bill of Rights, we don't just protect the right to life and liberty and due process. Pennsylvania expressly protects an individual's right to reputation. Right? That is so key. An individual's right to the reputation in the community. Obviously, like other states protect privacy interests, which can be consistently applied to Pennsylvania's reputation right. Importantly, though, the right to reputation could not be more directly connected to a lifetime public shaming on the registry. So we saw this as a perfect opportunity to attack the law with respect to kids. Now, the irrebuttable presumption doctrine, in very quick nutshell, right? Because I'm not going to get into the legal jargon around this. It basically says that if the state restricts some sort of right or privilege or creates a detriment to somebody based on a presumption about that person. Here, that the individual who's registered is basically, it poses a high risk of committing sexual offenses while they're on the registry for the rest of their life. If that presumption is not universally true, and there are no other means of ensuring that people who do pose risks are properly registered or properly put into the community as far as notification according to what the state believes is necessary, then the laws must fail, right? Now, we all know, just seems common sense, it's certainly not universally true that every 14-year-old who commits a sexual crime is going to be a risk to commit that crime for the rest of their life. That's absurd. Just common, simple sense tells everyone that. And we knew this was great low-hanging fruit to attack because we had this wonderful doctrine, the reputation right in Pennsylvania, but I'll talk about in a minute how it could be applied more broadly. So we went after this, and we were incredibly successful in this challenge. So by 2014, we won in 3 county courts. In 2014, the PA Supreme Court addressed this law and basically unanimously found that it was unconstitutional under state law to register juveniles for the rest of their life. Hundreds of kids were taken off the registry. It was a massive initial success, and many of you are probably aware of that case. Second, the other thing we started challenging, as I said early on, were these sorts of concepts of narrowing statutes, statutory interpretation. I've got Snoopy up here under the book because this stuff is so boring, right, for non-lawyers. The public doesn't care about this stuff, which is why it posed such a great opportunity for us to go after it, because it could impact so many lives that we saw it as a great resource and a great way to go after some of these claims. So first, what we did is we went after basically an area of law that said Pennsylvania enacted this recidivist provision that said if somebody has 2 or more convictions of offenses of tier 1 or tier 2. Now, you all know that under Adam Walsh, there is a tier structure, tier 1, tier 2. These are the lesser serious offenses, supposedly, right, and tier 3 being life. Now, in Pennsylvania, they said if you had 2 or more convictions of offenses that are tier 1 or tier 2, you are now a lifetime registry. Well, we were saying, you know, the state police, our state, was interpreting that law as saying you could have 2 charges in the same case and convicted of both crimes, and therefore the person was up to lifetime. For example, right, in Pennsylvania, they would always charge, many counties would charge individual images of child pornography as as individual charges. So some people would have 5, 6, 7, 8, many convictions, individual convictions for one count of those crimes. Now, under the law, it was supposed to be a tier 1, but because there was more than one conviction in the same act, the state would necessarily elevate all those people to lifetime registrants. And this happened across the board with all sorts of offenses. That's just the best example. We challenged that. And in 2 cases, Commonwealth v. Lutz Morrison and AS v. Pennsylvania State Police, we won in the PA Supreme Court. And they said, you know, That's dumb. This law is meant to be recidivist. It's meant to somebody who has a chance to rehabilitate and then offends again, or the people where want to up to lifetime. That's what they said. And we said, yeah, that's the right interpretation under this law. Well, the effect of that was to basically drop about 2,000 people from lifetime registrants back down to 15 years. So it gives them at least a hope, a window of being removed from the registry. Thousands of people got the benefit. It didn't make the news. It didn't make, huge waves in the legal community early on. But that's what we wanted. We wanted success here. Because also, what I'll talk about too, is that these cases kind of fit in with that basic principle in our early lessons, which is teach the judiciary and criminal participants about the law. So we were using these cases to continuously inform courts about the effectiveness or the lack thereof of these statutes and how complicated and onerous they were, so we could build those blocks over the years to help judges and jurists and criminal participants understand just how bad these laws are. Third area, right? Plea bargaining. Gosh, our system, right, in the words of the Supreme Court, is our system is a system of pleas, not a system of trials. We all know that most cases in this country, when somebody's charged with a crime, resolve by the way of plea bargain. They don't go to trial, right? We have this very perverse incentive structure in this country to overly and punitively punish people, threaten long, long periods of jail, and we coerce people to plead guilty to supposedly, relieve the state of its obligation and cost of taking a guilty person to trial. These are incredibly coercive and I think inappropriate structures of our system, but regardless, we know that the plea bargain is important and the court system would fall apart if it didn't protect it. So we thought, when SORNA came into effect, it was retroactive and it increased the length of time of registration for thousands and thousands of people in this state, right? Many people went from 10-year registries, and they were close to being finished, to lifetime, to 25 years when SORNA came about. Thousands of people were jumped up. And we said, most of those people pled guilty to their crimes with the understanding that they were not going to be registered, or with the understanding that they were only going to be registered for 10 years because these things were important to their plea agreements, right? For anyone who thinks, and no one, I think, joining this conversation believes this, but many people don't realize the importance of the registry and the collateral consequences of criminal convictions to the decision to go to trial or plead. But we do, criminal participants do, judges do. And we said, you can't retroactively, this is not an ex post facto argument that you've all heard of, that the law is punishment and therefore can't be retroactively applied. It's a due process argument that said when people pled guilty to crimes, knowing full well that their agreement included things such as the length of their registration, meaning they would not have pled to the charge they did if they thought they were now gets the benefit of increasing your registry for the rest of your life, or whatever that time period is. Ultimately, the Pennsylvania Supreme Court decided in our favor and held that plea agreements are not limited to withdrawal of charges or the length of a sentence. They may agree to and seek enforcement of terms that fall outside those areas. So anything that's material, the length of registration that's material to the plea, those get enforced as specific performance. Thousands of people then challenge the law to be dropped back to what their original plea bargains were. There's no registration or 10 years. Thousands of people got the benefit of those. And like I was saying, finally, in our initial sort of attack to the system, we have this concept that exists around the country in courts, both federal and state, affirm for any reason doctrine. If you win in trial courts, right, the appellate courts, when the state or somebody else appeals, can say, even if we don't agree with the reason that the trial court granted you relief, We can affirm that decision for any other reason as long as it's a matter of record, right? Which is huge. What it allowed us to do, as I said, is teach the judiciary. So instead of just focusing on the specific claims at issue, if the record supported us in these cases, we would make all of the other constitutional claims either through an amicus brief, right, or bringing in our own arguments at the end as alternatives, affirm the decisions below, because we would win in the trial courts left and right on these cases. So we have informed our superior, our intermediate appellate court, and our Supreme Court about this. So we argued to affirm for any reason. This is also called affirm for any ground in many of the federal and other state courts as well. And Martinez is a good example of that. We filed a massive, massive brief in this area that basically included every argument we could think of, not only the plea bargain, but many other constitutional claims as to why we should succeed. The court didn't rule on those, but we set the stage with giving them information, giving them articles, giving them evidence, giving them arguments as to why we should succeed. And I think those are incredibly valuable tools if you win at the trial level. So where did this all get us, right? Between 2012 and 2017, when Pennsylvania enacted its brand new law, I basically tracked monthly data from the state police. And what you can see here is that black line on top is the total registry population in Pennsylvania from 2012 to April of 2017. You can see it, that big bump on the left side. That is the time when SORNA was put into effect. And the lines at the bottom are the tiers. That red line is lifetime registrants, as most people were lifetime. Despite all of our successes, the registry kept moving up and up and up. So even though we got about 2,000 people dropped from tier 3 back to lower tiers, you can see those bumps down. And each one of those lines is 1,000 people. Those orange lines across there, by the way. So that's a lot of people that were affected by these decisions. But the total number of people, Pennsylvania was working like a machine and the train and it just kept on running, registering more and more and more. Even with, we couldn't keep up to the number of people Pennsylvania kept trying to drive onto the registry. So what did this tell us? Don't take your foot off the gas, right? No matter, even though we spent 4 years basically between 2012 and 2015 and 16, when we succeeded in getting JB and Martinez and the other cases successes in that 4-year period, we knew that it wouldn't stop the train. It wouldn't stop that snowball going down the hill. And we knew we couldn't take our foot off the gas. And we knew, which is why we were educating the court all along, that we would eventually have to make the big challenges. Right? The major claims that say, now it's time to try to strike down the entire registry in Pennsylvania. That's what we knew we had to do. So while Martinez, the last case that I talked about, was pending, right, we decided that it was time. We were waiting for the outcome of that case. We thought we would be successful based on the arguments, and we decided, the arguments at the Supreme Court, and we decided that it was time to try to make a challenge to the registry as a total. So I have this Back to the Future slide there. Why do I have this? Well, we made a decision. In 2015, we started filing and sent out across the state template motions, right, to try to challenge the entire registry. Arguments about what could happen when we made these claims to try to bring constitutional challenges to to the entire provisions. We decided that instead of attacking prospective cases, we would look at the ex post facto, the retroactive portions of the law, the people who were classified under SORNA, whose convictions occurred before that date, right? That was a decision we made at the time, making a facial challenge to the adult law to people who were convicted before SORNA, who found themselves wrapped up in a more onerous system than at the time they committed their crimes, right? We wanted to attack the premise of SORNA. And what we did is made a bunch of claims, both ex post facto, saying that SORNA is punishment, which means that the state cannot apply it retroactively, And we made claims that SORNA violates due process. So it's not about punishment. Even as a civil matter, it cannot be imposed because the way it's currently structured is impermissible under law. Basically, the due process argument attacks the premise of SORNA, that people convicted of sex crimes and supervised by the system are inherently likely to recidivize, that they're a danger to the public, that they have to be monitored. The due process argument fundamentally attacks that and says none of that is true. It deprives people of constitutionally protected rights, and it's absolutely required that they are given a sufficient process to be able to challenge that presumption, right? And the law does not do that. But we made the primary decision that we'd focus on the punishment aspect as the priority claim. Now, I'll talk to you in a second why I think that decision was ultimately wrong, but regardless, that's what we did. And we sent out template motions across the state, hoping that certain cases would bite so we could take them up to the Supreme Court. And instead of just focusing on one challenge that always has trouble getting movement in some way or another for whatever reason, right, we focused all over the state of Pennsylvania and basically created an army of people filing these petitions on reasonable cases. So this case, Commonwealth v. Munez, was the case that many of you may be familiar with that reached the Pennsylvania Supreme Court in 2017. Specifically, right, Pennsylvania v. Munez says that we argued all of those due process and ex post facto claims, but the court reached only the ex post facto one and said, we agree with the petitioners that SORNA is punitive, that the registry in its current form in Pennsylvania is punishment. It is not simply a collateral consequence or a regulatory law that cannot be challenged as part of a criminal sentence and does not entail requiring the rights that people have when they're charged with criminal offenses, including the right not to be punished backwards. And the court agreed, and they found lots of reasons why SORNA is punishment. It shames, it provides requirements for in-person registration, so affirmative disabilities and restraints, right? It is not particularly, it has questions about effectiveness, and it is excessive for what it is trying to do, especially in Pennsylvania, which registers people who are not even charged with sexual crimes. So certain non-sexual offenses can be registered under the law. So what this law did, though, is it resulted, when this case came out, suddenly the entire registry was called into question. About 14,000 people could be removed because they were the people retroactively reclassified. So the legislature went into high gear, right? Because the effects were 3,000 people were reclassified to non-registrants, to registrants who were removed. So basically people who had been caught in the system, who hadn't been registered before and were suddenly in 2012, were removed. 4,500 people in Pennsylvania were classified back to 10 years. Hundreds of failure to register convictions were reversed. I mean, in our county alone, Philadelphia, we got over 100 people released from state prison. We reversed over 300 failure to register convictions with post-conviction relief petitions. I mean, the effects were enormous, but the legislature was terrified that an additional 12,000 people would have to be removed from the registry. The whole thing would come crashing down, and the state did not want to do that. So they very quickly passed a new law. And this goes to my lesson 5, is that ex post facto challenges, in my opinion now, have unfortunately, while they can have huge successes in the short term and really benefit the lives of so many people if we're successful, and their families have them removed from the registry, they don't actually have potential for reform. And we're seeing this trouble in Michigan right now, where, the Sixth Circuit found the law punitive almost 2 years ago, and they're still fighting, in Michigan to change the law and are not getting very far. Because the legislatures looks to find, well, how can we make it not punitive? So what few things can we take out here or there, but keep the laws much in the same form as possible? And so I really think this is why 4 reasons why the ex post facto challenges have limited potential going forward. It doesn't undermine the registry's flawed premise that people on it are likely to recidivize. It doesn't help most people going forward because anyone committing a crime now doesn't have the argument. It's an easy fix for the legislature. They just take out the supposed offending portions. And then there's sentence finality problems, because if it's a crime, you have to get back into court to challenge it sometimes. It can't be done civilly, and there's all sorts of time limitations and sentence finality problems. So all of these reasons is why I think that ultimately the due process arguments will fare better in the long term. Even under in state courts. Federally, I'm not optimistic, but in state courts across this country, we have seen success. So what the legislature did, and this goes to one of my last points, is the PA legislature in 2018 passed SORNA 2. So basically trying to fix Muniz. So Muniz had about a six to 8 month lifespan before it was undercut by the legislature that reenacted a law that did almost the exact same things as SORNA, with very limited exceptions. It cut out a few things here and there. It made a removal provision that is largely illusory. After 25 years, a person becomes eligible to be removed, but they have to petition. They have to have committed no additional offenses, including failures to register. They have to prove basically they have to prove a negative that they are not likely to reoffend, as opposed to a positive that they are, because the presumption remains. It's a bad law. It triggers just almost as many people to be registered going forward. So, but it's also a very confusing law, right? And we realize that this law not only is almost just as bad in every way, maintains the false premise, now creates more confusion. The whole law itself under the new statute is 122 pages. It involves both retroactive and prospective classes of people. It has all sorts of cross-referenced retroactivity provisions and definitions. It is incredibly relying on old laws. It is incredibly, incredibly complicated. And the courts are now more frustrated than ever, right? So we knew we had to go back to court and challenge round 2. And I think too, I'm probably going to talk for about another 10 minutes and then have opened up for questions or so, 10, 15 minutes open up for questions. And I think that's probably good to where we are. But let's talk about this round 2. So after Act 10 and 29, SORNA 2 were passed into law in Pennsylvania, right? We decided that, okay, no more even kind of beating around the bush. This is the time that we just need to go full frontal attack on the new law as being unconstitutional, focusing primarily state constitutional law and federal law, but focusing primarily on state, looking at these due process arguments, attacking the basic premise of the law, that there is no evidence that the legislature is being fundamentally insincere and unreasonable and irrational when it made this statement that people on the registry pose a high risk of committing future sexual offenses. And that presumption is just fundamentally false, and attacking the presumption that the registry works, right? We needed evidence, we needed experts, we needed a full-on attack. So we filed these challenges. We came up with experts. We hired them. Many of them will be familiar to you. We got long expert reports and basically filed challenges across the state in a number of cases, many in Philadelphia where we were lead counsel, some in other counties around the state where we thought we might have courts that would at least give us hearings on this evidence. And what we did is the lead case ended up, pardon me, becoming this case called Torcellari. And we went forward on these matters and had our experts provide all that evidence to the Commonwealth and the Commonwealth of Pennsylvania. So let me step back too. Our state is a Commonwealth, not a state. So when I refer to the Commonwealth, I'm talking about the government, just to throw that out there and make it all clear. But the state here, they responded by saying, we don't care about your experts. We think it's irrelevant and we're not going to try to rebut it. Not that they had good evidence to do so, but they agreed to stipulate to our testimony and not seek to rebut. We won in the trial court in this case. In an 88-page opinion, a judge in Chester County found that Pennsylvania's law violated due process left and right. It agreed on the irrebuttable presumption doctrine. It agreed that it violated strict scrutiny and the right to reputation. It agreed that it violated procedural due process by not giving adequate hearings and challenges to this presumption that is in the law that the person is a risk to recidivize. We also had challenges go up that focused exclusively on the retroactive version, because we knew we needed to attack both chapters of the law, because now the legislature did not just have a single chapter, it had two chapters that affected two groups of people. So we knew we needed broad challenges here. And that case was called Lacombe. And these cases progressed throughout the lower courts. And like I said, we won in each one of them. Lacombe in the trial courts. So Lacombe goes up to the Pennsylvania Supreme Court. In 2021, July 21st of 2020, the Pennsylvania Supreme Court decided Lacombe. And in that case, the due process arguments were unfortunately not raised in the original trial room. So that was not our case going forward. But when they were raised by the trial counsel, they only focused on the retroactive punitiveness, relying on the Munez decision. And it's a good argument because the laws aren't that different. But the Pennsylvania Supreme Court drew a law in the sand. And they said, you know, we're not going to fight this. We're not going to fight this litigation forever by simply saying we're going to claim the law is punitive. The legislature goes back, makes one minor adjustment. Somebody challenges it again. We're going to have to draw a line somewhere. And this is the problem with the ex post facto argument, is that it requires line drawing about what is or is not punishment based on some pretty arbitrary changes in the law. And the court said, we're done. We're going to find that this retroactive version, which has less requirements than SORNA did, goes back to older versions of Megan's Law, basically, is not punishment. And the legislature can impose it retroactively. It was a huge loss for thousands of people who are retroactively registered in Pennsylvania. But there are some important caveats to the opinion. The court in 2020 said, but here are the reasons why the new law is different than the law we found unconstitutional in Munez. Many of those things that it found unconstitutional in Munez remain in the prospective version of the law that it still attaches going forward to thousands and thousands of people whose crimes occurred on or after December 20th of 2012 and into the future. So it left open a big area to attack. The other case, right? Where is this case now? This matter attacks the prospective version of the law, and I am counsel with a number of other people on this matter. This is the one in which the state basically stipulated to our testimony. And this case is primarily what happened in the Pennsylvania Supreme Court is they punted. We presented all of this evidence that compellingly showed that the registry not only is ineffective, but that people are not on the registry are obviously not all alike, that this presumption is illegitimate, that the law doesn't do what it intends, that it violates strict scrutiny and the right to reputation, all of this. And the court punted and said, you make a good colorable claim, counsel, Mr. Torcelari. You make a great claim here. But, the Commonwealth didn't think they had a need to respond, and we're going to give them a second bite at the apple, which is not how litigation usually works. When one side decides that they don't feel it's necessary to argue any evidence, the court doesn't give them a second bite. They made that choice. They have to live with it. Not that they have any good evidence anyway, but the court here said, we're covering our ass. If we're going to strike down the registry in Pennsylvania and suddenly have 22,000 people not subject to register in Pennsylvania, we need to be sure that we can cover our ass with evidence. So what the court did is remanded it to the trial court for a further evidentiary hearing, kicking the can another 2 years down the road. It's incredibly frustrating, but that is what the Supreme Court of Pennsylvania did in this matter. So what that means is that going forward now, right, we are still in litigation in the trial court. The Commonwealth has filed motions to dismiss. We have filed additional motions objecting to that. We intend on having full evidentiary hearings and experts in support. It is incredibly, I think, going to be a full-on significant trial that's going to take significant time to resolve and will ultimately make its way back up to the Pennsylvania Supreme Court. But as we all know, this fight is not quick. These changes take a lot of time, and we're going to be making other challenges and taking other shots at the law in addition to this case going forward in different areas. Now, what I will say, though, is that some of these, even Lacombe, which was a loss, right? There have been that had a caveat in it too, that not only does it allow us to attack the punitive aspects of the new law, but it also really gave an opening to ways that we can get back into court. As many of you all might know, right? It's sometimes hard to get into court initially to challenge the law, right? They're so difficult to either file a civil suit with the necessary complaints and the evidence to get in and the cost and expense. Many states don't let you get back into criminal court, but we succeeded convincing the court in Lacombe that because this law changes so often, because it's unclear whether it's criminal or civil, that Pennsylvania's post-conviction law is not simply the only way to challenge this law, but you can file habeas petitions and this petition called coram nobis, which is some old Latin terms that allow people to get into criminal court to challenge the registry, even after their convictions might otherwise be served as far as probation, parole, or incarceration sentence. This is a huge victory for many people to be able to get into court to challenge the constitutionality or even the fact of registration. Because too, as we all know, state police agencies, these laws are complicated, they make mistakes. There are lots of times under these complicated laws that people shouldn't be on the registry just as a pure statute matter. So it allows people to get into court to, vindicate those rights. So even in the failures with Lacombe, it was a huge success. So going forward, we are optimistic about what the Torcellari case allows us to do. 5 justices in that matter basically said that our findings that we presented to the court were not just a colorable argument, but they really went far in, quote, debunking the settled view that of sexual offender recidivation rates, and importantly, recognized that it was not simply the relative rate. It's not simply the rate of reoffense that's important. It's relative rates of reoffense that are important. What I mean by that, for the court, now reoffense rates are not something that I think should be the sine qua non of litigation in this area. But what I mean by relative rates of reoffense is that the court is now really understanding that it needs to look not just at people who have sexual convictions and how much or how little they reoffend, but compare them to people who don't have sexual convictions. Right? Many of those individuals show the exact same reoffense rates. And if that's true, if we can convince the court of that, and they understand that that is the issue, then we win, right? We win because the registry, therefore, does not actually have that presumption that everyone on the registry is different, that they're different than everyone else. Reoffending is not some unique signifier that applies to everybody. We all know that people are capable of redemption and people are capable of changing their behavior, and people are not all likely to do this, right? Again, so the law has to fail once the court recognizes this and we present the proper evidence. And also too, right, I can't forget that there are thousands of people in Pennsylvania who, despite these losses we've had recently, and even though I have hope that we will eventually be successful in our new challenges, right, there are still thousands of people, many of whom I've gotten to know very well, many of whom I still have contact with on a daily basis, right? We email, we text, who have seen their lives turned around because we've succeeded in these cases. One of my clients had spent 20 years on the registry. He was 17 when he committed his offense, but tried as an adult. We won only recently court cases that said that JB case, that juveniles shouldn't be subject to the registry, should not apply also to adults so the registry should not apply to adult or to juveniles who were convicted as adults. So people tried when kids in adult court, And those people had been registered for the rest of their life, like my client. He had basically not lived with his fiance for a decade. They have kids together. She owns a business out of her home. He didn't want the business to be associated with the registry. He didn't want his kids being seen with him going in and out of the house. It was a disaster to their life. About 6 months ago, after winning this case in the superior courts, our intermediate courts, we convinced the courts that people tried as adults who are kids when they commit the offense also cannot be registered under the irrebuttable presumption doctrine. And the court struck down his registration along many others like him. He's now married. They have moved in together. He's 41, right? 20 years of his life have been taken away, but so much has benefited from this. And I can't speak to the more and more people who have seen their lives change for the better because of the work we've been doing. I can only hope that we'll be able to say the same for thousands more in the coming years. But we need to keep up this fight together. We need to keep working on this. We need to have participation. We need to have training and success in people who are willing to talk to others in the community. So with that, I thank you so much. And there's even been other cases that we've succeeded in recently in the last month or so that have shown that as applied challenges may be brought to have individual people show they're not likely to recidivize and be removed from the registry under constitutional due process grounds. So we've been still succeeding in cases around the state from all of the hard work that myself, many other colleagues have done around here. So thank you again, and I am so excited to continue fighting on this cause, along with many other criminal justice reform issues that I fight on a daily basis. And I'm very excited to take any questions that you guys may have.
Well, thank you, Aaron. Certainly appreciate your time and you being here with us this morning, this afternoon. We have about roughly 5 minutes.
Okay. Oh, I thought we had one. Sorry than that.
Well, we can go a little bit longer, but we want to close the program down for lunch. So we have a question here about torcillary. I hope I'm saying that correctly. And I know you've spoken at length about it, but for the sake of answering the question, what's the best and worst case scenarios in terms of the ultimate outcome in that case? And perhaps you might provide your take on what would be your preferred outcome in that case.
I mean, obviously my preferred outcome, I think, is clear, right? My preferred outcome is that we are successful in convincing the court that not only does the registry violate the irrebuttable presumption doctrine, but I think more strongly that it violates strict scrutiny and the idea that there is a denial of the right to reputation under a constitutional principle. And I think the reason for that is both convince the trial court, which I'm optimistic we will do. The experts we have, many of you know them, Elizabeth Letourneau, Joe Levinson, Carl Hansen, J.J. Prescott, a number of other people who've written extensively in this area, right? Not only convince the trial courts, but convince the Supreme Court as well that, these laws are fundamentally flawed. They are not narrowly tailored to achieve the ends that the government wants to achieve. We believe, and I think everyone does, that the government does have a compelling interest in ensuring that for the protection of the community, in trying to prevent recidivism of any crimes, right? Any types of offenses. That is a compelling interest. But to do so, the government must not simply arbitrarily pick out its boogeyman because it's politically popular. It must make decisions when it deprives people of their life, of their liberty, of constitutionally protected rights, reputation in Pennsylvania, privacy rights in many states. We've seen Alaska do this too, which used their privacy clause in their constitution to effectively say that the laws were too broad. I think we are going to be successful in this case in Pennsylvania. I think we will show that the laws fail strict scrutiny, that they fail irrebuttable presumption, that it fails even intermediate scrutiny, because as we all know, these laws aren't rational, right? Even a medium level of scrutiny. Mr. Giuliani doesn't seem to understand the structure of scrutiny in the law, but our courts do, and we do, and this law fails that. So I'm optimistic. It's going to be a while. I would expect we probably won't get answers from the Supreme Court for another year and a half or two. So it's going to take some time, but we all know, you got to be patient in this fight. So I'm optimistic.
All right. We have one here from Eric, who's thanking you for your passion and asking how we can go about, I guess, as advocates, getting public defenders in other states to become as proactive as you have been.
Yeah, I mean, I think, the value is kind of twofold. One, it's continuing to, support public defense agencies. Public defenders' offices, as we all know, are incredibly underfunded across this country. Many of them are overwhelmed. I've been lucky that the Defender Association has really allowed a lot of flexibility. And the other benefit here is that we are structured in a way that is not a state entity. We are not a state organization. We're a private nonprofit that contracts with the state. So we don't have the county oversight that many others do, right? Lots of public defender agencies aren't given the flexibility to work on impact work, do impact litigation, to understand these sorts of things. I would strongly recommend, supporting your public defender organizations, convincing them that impact work is desirable, talking to them, finding somebody who's passionate about that and supporting them and telling them, hey, go to statewide trainings and talk to other people about this, right? Really try to get involved in, statewide organizational efforts. And that's what's important, is that most states have these public defender organizations that are statewide. I would highly recommend that if you know someone who's interested in this area but doesn't know what to do, have them go to these state public defender trainings. And you know what? Say to them, you know about this law, you're good at this law, why don't you lead a training on it? I will tell you, that's how I got involved. I learned about it early on, and someone said, oh, you know what you're talking about here within the first 6 months of this law. Why don't you lead a training to Carlisle County out in the state? And as soon as that person does that, they're the ones people go to, and you develop a network and a coordinated effort that will pan out across the state.
All right, thank you. We have a question here about the Chester County Judge's 88-page opinion. How would you find that? Is there a way to get a hold of that opinion?
I don't know if it's available online. I don't want to post it, largely because all of you know too that it may be available, but I prefer not to detail the contents of my client's life as much as possible in the in the public sphere. So the Pennsylvania Supreme Court's opinion is there. There's many other briefs on this issue that are available. But I don't know if it's available online, and I'm generally not that keen on posting it broadly because of my client's interests in protecting his privacy, as you all know.
Understood. Somebody asking again about the Torcellari case. What is the central argument? Again, you covered this, but is it due process? Is it irrebuttable presumption, or is it the right to reputation? What is your central thrust?
It's all three. So essentially, we use the right to reputation as the prime deprivation, saying that SORNA deprives someone of their right to reputation, which is constitutionally protected in Pennsylvania, right? And because it's constitutionally protected as a fundamental right, therefore, all of these other due process principles, the irrebuttable presumption, saying you can't deprive somebody of a right based on a categorical presumption about that person, unless the state shows that presumption is universally true, meaning absolutely everyone who has presumed that and therefore deprived the right without an ability to rebut it has to fit the bill, right? We're going to undercut that because we all know that not everyone on the registry has, quote, poses a high risk to sexually recidivize. That's absurd, right? It's absurd across the board. We know it's not true indefinitely. Science wins, pure and simple, right? And common sense should win. Further, right, we're also looking at strict scrutiny, which is because there's a deprivation of a right, that the right to reputation forces the state to say, before we can deprive it, we have to show that there is a compelling state interest and that it is narrowly tailored, right, confined to meet that interest. SORNA is not narrow at all. It's expansive, it's categorical, it's sweeping, and it drags in thousands and thousands and thousands of people who don't fit the bill that the government is interested in. And the law is ineffective. It doesn't achieve the end. So how can you have a narrowly tailored law that doesn't achieve the goal? It fails strict scrutiny. Those are our two big arguments.
All right. Thank you. It is now by my clock, 12:56. I want to express our real appreciation for you sharing with us here this afternoon. I keep thinking it's morning. It was very informative. There's a lot of good comments in the chat box here. So we just thank you for your time and appreciate it. Hope we can have you back in the future for a future webcast. That'd be great. So thank you, Aaron. If you have any last words before I turn it over to Don, go ahead.
No, I appreciate it, and thank you, Narsal, for inviting me here. And I'm happy to speak to you all today. And I'm, just excited that there's so much interest in this issue to, keep the agenda moving. And I know the tide is starting to shift. People are starting to understand the science, and many others just keep supporting the work. And thank you so much for having me.
Thank you. All right, then I'm going to turn the program back over to Don. Don, take us to lunch.